Hello, my name is Megan Brown.
And I am Selena Lacerna.
We are both outreach officers with the Bureau of Consular Affairs within the U.S. Department of State. One of the responsibilities of our Bureau, the Bureau of Consular Affairs, is to educate and ensure that jails and prisons are aware of and carry out Consular Notification and Access Procedures, or CNA for short, when a foreign national is placed in their custody in the United States. We have found that the best method of ensuring compliance is by education. Many jails and prisons in the U.S. might house very few foreign nationals and may not have even heard of CNA. It is our goal that by the end of this training, you will know what CNA is and why it matters. Before we jump into training, I want you to think about the following scenario and what you would do in that situation.
An adult male British national was arrested and detained at USB Lee in Pennington Gap, Virginia. He asks if his consulate will be visiting him while in prison and asks to make a phone call to his embassy. In this situation, what should the prison do? Pause the video here and take a minute to discuss the scenario.
We'll come back to the scenario a bit later in the training. For now, let's talk a little bit about the mission of our Bureau, the Bureau of Consular Affairs. The highest priority of the Bureau of Consular Affairs, or CA for short, is to protect the lives and serve the interests of U.S. citizens abroad. Across the globe, we serve our fellow citizens during some of their most important moments. Think births, adoptions, medical emergencies, deaths, arrests, and disasters. We also help U.S. citizens connect with the world each year by issuing millions of U.S. passports. The State Department has two main functions pertaining to consular notification and access domestically, which are carried out by CA. We educate U.S. law enforcement about these requirements, and we investigate allegations of violations or noncompliance of the treaties for the entire United States.
So what is consular notification and access? It's the process of informing a foreign government representative of the arrest, detention, or death of a foreign national and allowing the government to communicate with its nationals. The foreign government representatives we are usually in touch with are called consular officers. Consular officers normally assist and protect citizens of their own country when those citizens are abroad. The United States has consular officers in over 200 locations around the world to assist American citizens who need help. Consular officers can only provide assistance to detained nationals if 1. They know about the detention, and 2. They are allowed access to the detainee by local officials. These procedures are what make up consular notification and access. These consular notification requirements are set forth in numerous international treaties and agreements, most prominently the 1963 Vienna Convention on Consular Relations, or VCCR, a multilateral treaty to which the United States and more than 170 other countries are party. These treaties are binding on federal, state, and local government officials. In other words, they are the law.
So, why do we go to such great lengths to ensure we are complying with these procedures here in the United States? Well, not only are we a nation that meets our obligations, but by doing so, we help ensure that Americans abroad receive the same consideration from foreign governments. Millions of U.S. citizens travel and work abroad every year. If they're arrested, U.S. citizens rely upon us, the U.S. State Department, through our diplomats and consular officers posted overseas, to assist them. To do that, U.S. consular officers need to be notified, and they need to have access to those arrested to ensure that they have adequate food and medical care, are able to contact friends and family, and have access to an attorney. If you remember only one thing from today's presentation, let it be this. The way we treat foreign nationals here in the United States can and does affect what happens to U.S. citizens who are in trouble abroad. That is absolutely crucial to understanding why CNA is so important. Under these treaties, Americans detained abroad have the right to have the U.S. consul notified of their arrest, but American citizens in that situation may not know that unless the corrections officer tells them. The same goes for foreigners arrested here. Not every foreign traveler knows this. Someone has to tell them, and that would be you.
Consular notification and access obligations apply to all foreign nationals in the United States. So, who is a foreign national for CNA purposes? Any person who is not a U.S. citizen is a foreign national. This includes short-term visitors, lawful permanent residents or green card holders, and undocumented foreign nationals. As you know, many U.S. citizens also have another nationality. Consular notification and access obligations technically do not apply to dual national U.S. citizens. However, we ask you to notify the consular officer of the other country as a courtesy. We want to know when U.S. citizens who are dual nationals are arrested in the other country. So we need to do it here in order to expect that from authorities abroad. As I mentioned, a consular officer in the United States is an official of a foreign government accredited by the U.S. Department of State and authorized to provide assistance to that government's citizens in another country, regardless of whether a consular officer is assigned to an embassy in Washington, D.C., or to a consular office maintained by the foreign government at another location in the United States. Some of you may have heard the term honorary consul. An honorary consul is a person authorized by a foreign government to perform official functions on its behalf in the United States. Honorary consuls should be treated in the same way as consular officers when they are performing official consular functions on behalf of citizens from the country they represent.
Now for the notification procedure. Notification must be offered and/or made within 24 to 72 hours after the initial arrest or detention. This notification process is outlined in a flowchart available for download on our website, as well as included in the CNA manual. On our website, travel.state.gov/CNA, we list all contact information for embassies and consulates located in the United States. Simply search by country. All email addresses listed are hyperlinked for ease of notification. The longer the detention continues, the more likely it is that a reasonable person would conclude that the notification obligation is triggered. Even if the national is only detained for a few hours, go ahead and make or offer notification. Remember, it is better to be safe than sorry. And if the foreign national has been arrested or detained for such an offense that it's obvious that he or she isn't going to be released anytime soon, go ahead and make or offer notification as soon as you can. As for how to notify the consul, email is the preferred method of communication. However, the fax machine, believe it or not, also works 24/7, and the fax confirmation sheet provides a written record of notification. The copy of the notification email that you sent is also a good written record that you sent notification. Please remember that keeping good records is critical. It is essential not only to provide notification, but to document it. In the event the detainee or the detainee's attorney or even foreign government later claims that no offer to make consular notification was made or that notification never happened, you have proof. If you notify in any other way than by fax or email, such as by telephone, make a note in the file of the date, time, number you called, and the name of the person you spoke with.
Depending on the procedure you have in place with local law enforcement agencies, you may provide consular notification at booking or intake. So, what are the CNA requirements when you detain a foreign national? Well, it depends on the treaty that we have with each country. There are 58 mandatory notification countries, and we will explain them in further detail on the next slide. Notification to the consular officer must be made whether the detainee wants it or not, if they are a citizen of these 58 mandatory notification countries. If the detainee asks you not to make the notification, you should explain that you have no choice. It's a legal requirement. The notification requirement should still be honored if a detainee has applied for asylum. But do not disclose any information related to that application to the foreign embassy or consulate. If a consular officer insists that they are entitled to information about a detainee that the detainee does not want disclosed, please contact the State Department for guidance. For all other countries, the requirement is that you must offer to notify the detainee's consulate. The foreign national can accept or turn it down. Keep a record of that person's response. This is important in the event there is any question regarding consular notification.
Here's the list of the 58 mandatory notification countries we spoke about earlier. To reiterate, if anyone comes to your jail or prison that is from one of these countries, ensure that during intake they have been made aware of CNA and that by law you will notify their nearest embassy or consulate that they are now in your facility, whether they want you to or not. The national does not get a choice in this. Going back to the scenario presented at the beginning of this training, based on the information we have provided so far, what do you think the corrections officer should do? If you said, provide notification to the UK embassy, since the UK is a mandatory notification country, you'd be correct. It is important to know that allowing an arrested or detained foreign national to call his or her consular officer does not qualify as consular notification. Notification must be made by the arresting or detaining law enforcement authority to fulfill treaty requirements.
If a detained or incarcerated foreign national originally turned down consular notification following their arrest, but asks for it while in detention or while serving their sentence, you must provide notification to the foreign embassy or consulate. There can be instances when a foreign national changes their mind. In these situations, send consular notification immediately and keep a record. The foreign embassy or consulate may complain that notification was not provided immediately after the arrest. If the arresting agency has a record that notification was declined initially, and you have a record that the foreign national changed their mind and you sent it, the State Department can obtain all the information needed to verify that the correct procedures were followed and to respond to the complaint.
This is something that comes up quite frequently when we speak to embassies and consulates. We understand that inmates can be transferred to different facilities. When these transfers happen, notify the foreign consul when their foreign national is being transferred to another detention facility or into your facility. Email and fax are preferable as you will have a record of the notification. If necessary, you can call the foreign embassy or consulate. But again, please make sure to keep records of all notifications.
It is a good idea to notify the foreign consular officer when a foreign national becomes seriously ill. Though serious injuries are not specifically covered in the treaties, the Department of State encourages U.S. officials to make notification in any situation where a foreign national is in such a critical condition that contacting consular officials would be in that person's best interest. For example, if that person is in a coma or in an ICU. In other words, they are unable to communicate with family or friends to let them know that they are sick or have been injured. If inmates or detainees are sent to a hospital or other medical facility for treatment, notify the foreign consular officer of their citizen's departure from your facility and where they are going for medical care. Also, notify the foreign consular officer when they return to your facility. Again, email and fax are preferable so you have a record of the notification. If necessary, you can call the foreign embassy or consulate. Keep records of the notifications.
If an inmate or detainee dies in your facility, every effort should be made to ensure that notification is provided to the foreign embassy or consulate, in addition to notifying the next of kin. Please send death notifications by email or fax, and again, keep a record.
After the foreign embassy or consulate has been notified of an arrest or detention, what happens next is up to the foreign government's officials. Consular notification and access obligations provide consular officials with the right to have access to their nationals. They can visit, call, or write. Whether they choose to do so and how they choose to do it depends on the traditions and resources of their home country and the location of the nearest consulate. Some of the services that consular officers provide for their nationals are listed here.
Consular officers are expected to follow the regulation of the detention facility regarding security and the time, place, and manner of their visits. But the regulation should not be so strict as to prevent consular access. We urge authorities to grant consular officials liberal access to detained persons, providing them every courtesy consistent with local laws and regulations. Liberal visiting privileges are particularly important when consular officers have to travel long distances to visit their citizens. Remember reciprocity. What access conditions would you like the American consular officer to have if visiting a relative of yours under arrest in a jail overseas? Consular officers are not permitted to practice law in the U.S., but they should be given the same communication privileges as defense attorneys. Consular officers may not interfere with criminal investigation or judicial process, and it is not necessary to delay an interview or interrogation to make consular notification or to wait for a consul's arrival.
So, why should you care about all of this? Quite simply, it's the law. The Supremacy Clause in Article 6 of the U.S. Constitution makes CNA the law of the land. We want to uphold our international agreements so that we can protect Americans overseas. If we comply with our international agreements, other countries are more likely to do so. CNA compliance helps avoid legal challenges. Defense attorneys may attempt to challenge prosecutions on the basis of failure to provide consular notification. There is the risk of running into a judge who believes that the appropriate remedy for a CNA violation is to have evidence suppressed or convictions overturned. Some individual U.S. states are putting legal remedies in place in the event of the lack of consular notification. Massachusetts, for example, provides for a new trial if lack of notification is seen by the judge as prejudicial against the foreign national's case. New York and Illinois also have consular notification laws on the books. Why take a chance on this? Following CNA procedures is easy, and keeping records of notification avoids creating grounds for challenges of convictions and sentences. Also, foreign consular officers can help you. They know the language and the culture of their nationals. They can contact relatives and be a resource for you. Finally, your efforts are critical to protecting U.S. citizens overseas. When we have trouble with a host government, we can honestly point to your hard work in making sure that foreign nationals are given proper consular notification and access in the United States.
Now, let me tell you about the resources that we have for you to make notification easier. Our CNA materials are available on our website, including the manual, notification flowchart, and a poster with the mandatory statements in several languages in the event the national does not speak English. You can also watch the 12-minute training video, convenient for roll call briefings. All these resources are available on our website at travel.state.gov/CNA.
Here are the ways that you can contact us if you need additional information or guidance.
Thank you for your time and attention. Please reach out to us if you have any questions, require physical materials such as the pocket cards or manuals, or have case-specific instances you'd like to discuss. This concludes the U.S. Department of State's training on consular notification and access for jails and prisons.